This is done by
Well, there you have it. Judge Cheryl Matthews handing down a sentence with a, without question, resounding victory for prosecutors in the case. And just so our audience understands the parameters of these sentencings, typically speaking, there are guidelines, and guidelines give the judges an idea of where they should be in the sentencing. And if I recall, in this particular case, it would have been anywhere between 3.5 and 7 years. Prosecutors had asked to go ahead of those guidelines, higher than those guidelines, because they alleged there were so many aggravating factors, things that would not make it a just sentence if they just did the standard guideline range. Of course, the defense was asking for either time served in probation or up to the minimum of the guidelines, 48 months. So that is a resounding win. Prosecutors got exactly what it was that they were asking for. So both Jennifer and James are going to be spending the next 10 to 15 years in state prison as a result of having been convicted in this, whatever your position is, novel legal theory of holding the parents responsible for the deaths that were created by their son. So, there you go, guys. We're going to have it there. I think what we're going to see down the road here is clearly, there's no question about it, this is not an indication on whether or not the case was a good case or a bad case, but there will be an appeal on the sentence and on the case. And what you are going to now see is an appeal that's going to be kind of bifurcated, or it's going to have two aspects to it. The first part is going to be, one, that this legal theory was untenable legally, that it's an inappropriate legal theory, that they didn't do anything that they should be held accountable for. The second part, as I see it, on the liability aspect of this appeal, is going to be that extraneous information that we were talking about before, what we refer to as character assassination evidence, came out, and that the prejudicial value of that evidence outweighed the probative value of the evidence to the jury, and that the jury therefore was deprived of making a dispassionate, non-sympathetic discussion and evaluation on the evidence and the law, but rather were persuaded by that pieces of evidence coming in. I can just tell you, as a former prosecutor who's admitted other evidence in a case, I always worried about the appellate courts and how they were going to view that. And now we're going to see, after the sentence of 10 to 15 years, giving the prosecutor the full boatload as to what they wanted, another aspect, in my opinion, on this appeal, where they're going to argue that the judge did not identify sufficient aggravating factors in the case to justify going beyond what the guideline range is in the case. So it'll be a multifaceted appeal, but just to be clear, so our audience is aware, an appeal is not a second shot. An appeal is not a second trial. An appeal has to be substantial errors that occurred that could have fundamentally affected the fairness of the trial. And so you can be assured that both sides are going to vigorously fight this particular sentence. So with that, you can see right now in court that the defendants are being taken out. I think they're probably going to be in a little bit of shock. I think most legal analysts believed that this was going to be something where the judge was going to, excuse the expression, but split the baby, if you would. Maybe not on the low end, certainly not on the middle end, but not certainly something that was as high as it was. So whether you like the case, whether you don't like the case, all I can tell you right now, I can assure you from having been in the spot, is prosecutors are right now celebrating this sentence.